Greetings and salutations. Welcome to another instructional episode from the Legal Beagle podcast. Today we're doing Municipalities Part 2. So just the overview of the American Jurisprudence on municipalities. If you get in our Telegram group, our municipality section is posted and you can read it all for yourself. But this is just an overview and gives you a good sense of what municipalities can and can't do. So without further ado, let's get into the Municipalities Part 2. Generally, local powers is limited by Constitution and general laws. There must always be doubt whether a matter which is of concern to both municipalities and the state is of sufficient statewide concern to justify a new legislative intrusion into an area traditionally regarded as strictly a municipal affair. Such doubt, however, must be resolved in favor of the legislative authority of the state. City of Los Angeles versus the state of California. Section 134, Health and Sanitation. The view has been taken that a municipality authorized to make its own charter may provide for a board of health with power to make and enforce regulations for the suppression of disease. However, it has been held that matters of health and sanitation, including sewage disposal, are of statewide concern, as to which the state is supreme over its municipalities and may impose duties and responsibilities upon them as agencies of the state. Section 194, Express and Implied Powers. The legislature of a state, merely by establishing a municipal corporation, does not delegate to such corporation the right to exercise all governmental powers of the state within its territorial limits, or even such powers as are commonly exercised by a municipal corporation of the same class. The general rule is that the municipal corporations possess and can exercise only such powers as are granted in express words, or those necessarily or fairly implied in or incident to the powers expressly conferred, or those essential to the accomplishment of the declared objects and purposes of the corporation. Only what the legislator has told them they need to do, and only if it falls under one of those things that they've been told to do, can they exercise their authority without the legislature's expressed permission. The same rule applies to counties. A county, as a subdivision of the state, and its board of commissioners or supervisors, as a creature of statute, have only such powers as are expressly conferred upon them by the state or necessarily implied from those expressly given. In numerous cases, the view is taken that a power may not be implied as incidental to powers expressly granted merely because it is useful or convenient. It must be indispensable to the attainment of the declared objects and purposes of the corporation. Read that again. In numerous cases, the view is taken that the power may not be implied as incidental to powers expressly granted, merely because it is useful or convenient. It must be indispensable. So if they've been expressly given the duty to take care of sanitation issues, and one of these something happens under the sanitation issue that they need to do, then they're allowed to do it. Otherwise, they need to go back to the legislature and ask for permission. Must be indispensable to the attainment of the declared objects and purposes of the corporation. So if they want to create a new sewage plant, it must be indispensable to the attainment of the purposes that the legislature sent to them. Right? However, the view has been taken that the power in a municipality may be implied, although it is not indispensable to the exercise of powers expressly granted. And even where the view obtains that an implied power must be necessarily incident to the powers expressly granted, or must be indispensable to the attainment and maintenance of its declared objects and purposes, changing circumstances must be considered, and consequently what might not have been implied at one time may be implied at a later time. I'll read this from a court citation. Necessarily implied means inevitably implied. A necessary implication does not mean natural necessity. but so strong a probability of intention that an intention contrary to that which is imputed to the body using the language cannot be supposed. Detroit Citizen Street R Company versus Detroit R Company. Section 195, construction of grants of power, strict or liberal construction. The rule is generally stated that the scope of sovereignty delegated to municipal corporations should not be enlarged by liberal construction. The powers conferred are strictly construed and are fair, substantial, and reasonable doubt concerning the existence of any power or any ambiguity in the statute upon which the assertion of such power rests. It is to be resolved against the corporation and the power denied. This same principle of strict construction applies with regards to powers delegated to the counties of their governing bodies. On the other hand, it has been held that an expressly granted or necessarily implied power of a municipal corporation should not be defeated by a stringent judicial construction, and that the rule of strict construction should not be carried to such an extent as to defeat the very purpose for which the power was granted. If proper to be exercised, where it is necessary to adopt a more liberal rule of construction of a corporate power to accomplish the results sought by the legislator, it should be done. And now we see how all these judges have so much leeway and with these corporations. Well, it's not necessarily implied then, but it is now. So when they start liberally construing things, this is where we go off the rails. While the rule of strict construction is generally stated in unqualified terms so as to apply to municipal powers of both government and a proprietary nature, a distinction is made by some cases to the effect that a statute conferring sovereign and governmental powers upon a municipality must be strictly construed, but powers given for the private advantage of it and its inhabitants are to be construed in accordance with the general rule that applies to private individuals or corporations. It has been stated, however, that the principle of strict construction applies with special force to statutes enabling municipalities to enter into commercial activity. While the enumeration in a statute of the powers which may be exercised by a municipal corporation is held to exclude such powers as are not enumerated, the intention to deprive municipal corporation of its common law powers will not be inferred simply because certain of such powers are enumerated and conferred by its charter, while no mention is made of the rest of them. So too, the passage of a statute expressly conferring power on a municipal corporation does not necessarily preclude the preexistence of the power. However, where a statute confers an extraordinary power on a board of county commissioners to create a new liability and provides a special way of discharging that liability, the mode prescribed is exclusive of all others. Obviously, such a board cannot incur for the county and any obligation beyond its income previously provided by taxation, whereas it is expressly prohibited by statute from following such course. Where particular powers are expressly conferred upon a municipality, and there is also a general grant of power, such general grant by intendment includes all powers that are fairly within the terms of the grant and are essential to the purposes of the municipality, and not in conflict with the particular powers expressly conferred. The law does not expressly grant powers and implied grant others in conflict therewith. Where a municipal corporation is established within the limits of a township, the authority of the municipality over subjects with respect to which it has been given authority is exclusive. Exclusive means solely, only. Section 196, delegation of powers by municipality. The same restrictions which rest upon the state legislature as to the delegation of legislative powers and functions conferred upon it by the Constitution are held to rest upon a municipal corporation as to powers granted to it by the legislature. So far as the functions of a municipal corporation are legislative They rest in the discretion and judgment of the municipal body entrusted with them, and that body cannot refer to the exercise of the power to the discretion and judgment of its subordinate or any other authority. Unless a statute specifically provides otherwise, legislative and discretionary powers vested in the governing body of a municipality cannot be delegated by such body to an administrative officials of the municipality. Thus, when the exercise of discretion is involved, a municipal council cannot delegate the power of enacting police regulations. What we're talking about, what's been delegated cannot be redelegated. Must be done on the city municipality level. It can't be delegated to an agency of the city. Thus, when the exercise of discretion is involved, a municipal council cannot delegate the power of enacting police regulations, of enacting and enforcing building regulations, of determining what improvements shall be undertaken and the character and extent of such improvements, of the approving of certain acts, of selling municipal bonds, of purchasing fire equipment, of entering into contracts generally, or of levying a tax. In this connection, it has been held that the regulation of traffic, including the establishment of parking zones with their time limitations and the fixing of fees for the use thereof, are legislative functions of a municipal legislative body which cannot lawfully be delegated to a parking meter commission. Perfect example. These principles, however, are not to be construed as to deprive municipal council of the power of delegating ministerial or administrative functions to subordinate officials. The fact that such power is vested in the municipal legislator does not mean that it is itself required to act in every case. Powers of a purely ministerial, administrative, or executive nature may be delegated by a municipal council to a committee or to some appropriate officer or board. A municipal corporation may delegate to subordinate officials the power and duty of carrying into effect valid ordinances adopted by it and provide all the machinery necessary therefor. Thus, a municipality may vest in its officials broad discretion in such matters as the application and enforcement of health laws, the administration of public gas, light, water, and sewage systems, and the administration or ministerial functions relative to the enforcement of building regulations. Again, the council or other governing body may authorize others to do those things which it may properly but cannot understandingly or advantageously do itself, and may properly delegate to administrative officers and boards the authority to promulgate rules and regulations and to make determinations as to the existence of facts in order to carry out expressly declared purpose or to affect the operation and enforcement of ordinances. And this is where we see that the zoning commissions have billed out to these private corporations with all these drones, and have mass assessed all of our property together. This is where they're going to get it from. This is where they're going to say they can. Rules and regulations promulgated, but let me state, a mass appraisal. If you appraise someone's property, then you have to have personal knowledge of it. So none of these corporations have personal knowledge of any of these properties that they assign value to. So it's not lawful. And Alphonse would be a good place to go to for examples of this. Rules and regulations promulgated by local commissioners and boards under authority delegated by a municipal ordinance are valid where they are subject to final consideration in the courts in order to determine whether they are reasonably adapted to accomplish the purpose of such ordinance. The delegation of authority with respect to the issuing and revocation of licenses is discussed in another topic. It is also recognized that the state may expressly authorize the delegation of certain powers by municipal corporations. Thus, a legislator may grant municipal corporations the power to appoint boards of health and prescribe their duties and powers. Under circumstances where power is properly delegable, Some cases distinguish between delegation to a board of committee and a delegation to a single individual, and will uphold the former while the latter will be held to be unreasonable and arbitrary. So a delegate to a board or committee, then it's a little more legitimate. A single individual, then probably not. Obviously, a municipal corporation cannot delegate authority which it does not have, and it may not confer authority except in the manner and for the purposes for which it may do the act itself. Section 197, to private individuals or corporations. A fortiori, since a municipal corporation cannot delegate its legislative and discretionary functions to municipal officials or even to a committee of the governing body, a municipal corporation cannot delegate to private individuals or corporations any of the government, legislative, or discretionary functions confided to it by the legislature. This would call into question those mass appraisals, right? You're delegating to and the parking meters and such like that. When you have an automated system by a corporation just sending you tickets in the mail, that's not allowed. The municipal employee that writes the ticket has to be employed by the municipality. Otherwise, it's completely invalid. And there's some there's some arguments to be made. It might be invalid altogether, but if the municipal corporation employee didn't do it himself, then it's absolutely not allowed. So says American jurisprudence. Thus, the power to fix the grade of a street cannot be delegated by a municipal council to a private individual or corporation, such as a contractor. However, the selection of an officer or employee upon the recommendation of a business organization, for example, a chamber of commerce or other civic association, is not a delegation of the power to appoint. And it has been held that an ordinance requiring a mayor to choose a city attorney from a specified number of candidates recommended by a panel of lawyers does not constitute an unauthorized limitation on the mayor's power or appointment, or a delegation of a substantial portion of this power. Lots of ways around all these little things. Lots of ways around. Under Section 198, surrender of power. It is declared to be against public policy to permit a municipal corporation to part with any of its legislative power. In the absence of a clear grant of power from the legislature, the municipal authorities can do nothing which amounts in effect to the alienation of a substantial right of the public. It cannot obligate itself not to exercise such powers, and a contract in which it purports to do so, even upon valuable consideration, is void. Thus, a municipal corporation cannot, by contract or otherwise, divest itself of its general police power. Can't hire private security, got to be hired by the city. Thus, a municipal corporation cannot, by contract or otherwise, divest itself of its general police power or of the power of eminent domain which has been delegated to it by the legislature, or of the power of taxation. A municipality's power to control and regulate the use of streets in the public interest cannot be surrendered or impaired by contract or otherwise, at least not without explicit consent of the legislature. A municipal corporation, when exerting its functions for the general good, is not to be shorn of its powers by mere implication. And if, by contract or otherwise, it may, in particular circumstances, restrict the exercise of its public powers, the intention to do so must be manifested by words so clear as not to admit of two different or inconsistent meanings. The duration of municipal contracts is affected by the foregoing rules relating to the surrender of powers as discussed in subsequent division. Section 275, generally, the rights, powers, and duties of the officers of a municipality are controlled by the provisions of the Constitution, statutes, charter, and ordinances, and it may be stated broadly that the officers of a municipal corporation cannot bind it by assumption of powers beyond those granted by the sovereign authority and not essential and indispensable to the declared objects for which it was incorporated. But though, for the most part, municipal officers derive their power and authority from the statutes, either expressly or by necessary implication, the right to define duties of municipal officers may be delegated to the municipality by the legislature. The municipal council may impose additional duties upon municipal officers in the exercise of its power to create or abolish officers. And it has been held that the additional duties which may be imposed on municipal officers under a statute, providing that they shall perform in addition to duties specifically prescribed, such additional duties as may be required of them by the municipal council may relate to the proprietary as well as to the governmental activities of the municipality. All action taken by municipal officers must be both legal and reasonable, and this is particularly so under general grants of power. Moreover, the officers of a municipal corporation have no power arbitrarily to interfere with the rights of a citizen in any case where the public interests are not involved. That's why they tried to make the mask about the general health of the public, so they can have authority to do so. But when they implement the mask mandate, it has to completely eliminate the problem. So the fact that you can still spread things through the mask doesn't completely get rid of the situation, so they're not allowed to do it. If the mask were 100% effective, then they could mandate the mask, but they're not. In the absence of any showing to the contrary, however, it will be presumed that county and municipal officers discharge the duties of their office and observe all necessary and proper formalities imposed by law in doing so. There is no presumption that such an officer has been influenced in his official action by proper motives, or that he will violate his oath of office in sinister pursuit of an unlawful purpose. The contrary is in fact presumed to be true. It has been held that in the absence of any legal provision, therefore, a municipal officer is not entitled to reimbursement for expenses incurred by him in attending a conference or convention of similar officials of other municipalities, when such attendance is not required in connection with the proper performance of the duties of his office. Well, we know that the city attorneys have some very artful language and determining what conferences are absolutely essential to municipal functions. So hard to get around these things with dishonest people. Section 343 generally. An ordinance of a municipal corporation is a local law and a regulation of a general, permanent nature. The general term ordinances has sometimes included all the regulations by which a municipal corporation is itself governed. There is some difference of opinion, however, whether ordinances are laws, quote unquote, within the meaning of statutory or constitutional provisions. And an ordinance has been held not to be within the meaning of the phrase contrary to law as employed in a pleading. Thus, a complaint containing the allegation that a defendant committed a described act contrary to law has been held not to aver an infraction of municipal ordinance. In general and professional use, the term ordinance is almost, if not quite, equivalent in meaning to the term bylaw. Some authorities have gone to the extent of declaring that the terms are synonymous. The term ordinance is now the usual denomination of local laws, although in some states, the technically more correct term bylaw or bylaw, BYE law, is in common and approved use. The main feature of such enactments is their local applicability as distinguished from the general applicability of the state laws. Hence, according to some of the critical analysis, the word law with the prefix by or by should, in strictness, be preferred to the word ordinance. Bylaws of the corporation. If you're not a member of the corporation, you shouldn't have to follow any of the bylaws. So this is, something that hasn't been stated, clearly sometimes. And you must be very, very precise if you're going to challenge these things. and you must have a judge that, might want to follow the law, which we can't seem to find too many of these days. It may be stated generally, subject to limitations hereinafter set out, that the powers of a municipality are to be carried into effect and discharged through provisions of ordinances or resolutions enacted by the council or other governing authority. The distinction between ordinances and resolutions is discussed in the next section. Distinction, section 344. Distinction between resolutions and ordinances. The term resolution denotes something less formal than the term ordinance. Generally, it is a mere expression of the opinion or mind of the council concerning some matter of administration coming within its official cognizance, and provides for the disposition of a particular item of the administrative business of a municipal corporation. It is ordinarily a temporary character, while an ordinance prescribes a permanent rule of conduct or of government. A resolution is not a law, and in substance, there is no difference between resolution, order, and motion. Section 345. Ordinances as laws within meaning of statutory and constitutional provisions. The courts have reached different conclusions, dependent upon the wording, purpose, and meaning of various statutory and constitutional provisions. Whether ordinances enacted by municipal corporations constitute laws within the meaning of such constitutional and statutory provisions containing the word law or laws, in many cases involving various types of state statutes. Ordinances have been held to be laws within the meaning of the term as used in such statutes. Similarly, ordinances have been held to constitute laws within the meaning of various state constitutional provisions and of the federal constitution and federal statutes. Generally, they constitute laws of the state within the meaning of the 14th Amendment to the federal Constitution, so as to permit review of final state determinations to their viability in respect of such amendment, and within the meaning of the federal Constitution in its inhibition of the passage of laws impairing the obligation of contracts. In some instances, however, municipal ordinances have been held not to be laws, as that term is used in state statutes, state constitutional provisions, and federal statutes. It has been stated that an ordinance is not in the constitutional sense a public law, but is, rather, a mere local rule or bylaw, a police or domestic regulation, devoid of many respects of the characteristics of public or general laws. So they've left it open. They've left it open. Section 361, generally, it is an elementary principle of law established by the unanimous concurrence of all relevant authorities that municipal ordinances must not be inconsistent with or repugnant to the federal and state constitutions, which we've told you already. So far as their constitutional validity is concerned, they are considered in the same light as laws of the state and must conform to the supreme organic law in every respect. The test of validity of a municipal ordinance is whether or not it offends constitutional guarantees and whether or not it is reasonably designed to carry out a proper legislative purpose. In which respect, of course, the ordinance must be one which the municipal legislative body has the power to enact. Generally, also, a municipal ordinance, in order to constitute a valid exercise of local legislative power, must be reasonable and not arbitrary, and must be certain and definite, and must not conflict with the general law of the state on a matter of statewide concern. In determining whether a municipal legislative act is constitutionally valid, its substance, and not its form, must always be the test. The constitutionality of an ordinance is also determined not alone by what has been done, but by what may be done under its provisions. And a treatment of the United States stands for the same footing as far as municipal ordinances are concerned as the federal Constitution. The general discussion of the meetings and proceedings of a municipal council or other governing body including the necessity and existence of a quorum at the time of enactment or of legislation or other action by such body, and the number of votes necessary for effective action by the governing body, will be found in an earlier part of this article. Ordinance should be scrutinized more carefully for its inhibitions against pursuit of a right as distinguished from a benefit. Jewish Reconstructionist Synagogue Incorporated versus Roslyn Harbor. A municipal ordinance is valid unless it clearly bears no real and substantial relation to public health, safety, morals, or general welfare, or is unreasonable and arbitrary. East Cleveland versus Palmer. Section 364, equality, generality, and uniformity generally. Ordinances must, as a rule, be general in their nature and impartial in their operation in order to be valid. They must be uniform in application to all citizens and afford equal protection to all alike. If they grant rights, they must provide for the enjoyment thereof to all upon the same terms and conditions, and they cannot penalize one person and for the same act done under similar circumstances impose no penalty on others. All in all, they must not be discriminatory in favor of one person or class of persons over others, and must operate equally upon all persons as well as for their equal benefit and protection who come or live within the corporate limits. So just like the mask mandates, you can come in with a mask, but you can't come in without a mask or the jab or whatever. You know, you can't, that's different classes of people. And so you're being discriminatory at that point. That's not allowed. Of course, you might challenge this in court, find a judge to overrule it. You know the issues. The above principles do not mean, however, that municipal ordinances must affect every man, woman, and child alike in order to avoid the constitutional prohibition of denying the equal protection of the laws. The Equal Protection Clause does not forbid discrimination in ordinances with respect to things which are different, and moreover, the rule of equality permits many practical inequalities. What satisfies this equality has not been and probably never can be precisely defined. Ordinances of a city will not be declared void under the 14th Amendment to the Federal Constitution on the ground that they deny a person the equal protection of the laws if within the spirit of their operation they affect alike all persons similarly situated. Thus, ordinances do not violate the Equal Protection Clause of the 14th Amendment where they affect all persons engaged in the same business equally under like conditions. Good example right here. Plaintiff alleging denial of equal protection due to discriminatory enforcement of a valid city ordinance regulating the size of commercial signs failed to prove conscious intentional discrimination by the city in view of the fact that three other persons were convicted under the same ordinance on the day defendant was sentenced. People versus Goodman. Constitution of the United States requiring that no state shall deprive any person of life, liberty, or property without due process of law has not undertaken to equalize all the inequalities which may result from the exercise of recognized state authority. In the exercise of the police power, it may happen, as it often does, that inequality results which the law is powerless to redress. It is only in those clear and unmistakable cases of abuse of legislative authority that the court is authorized under a section of the federal Constitution to enjoin the exercise of legislative power. Section 398, generally. The courts have stated on numerous occasions that in general, the rules to be applied in construing municipal ordinances are the same as those applied in the construction of statutes enacted by the legislature. Rules of statutory construction. Go read them, go learn them, go understand them. Ordinances must receive a reasonable construction and application, and the primary rule for their interpretation and construction is that the intention of the municipal legislative body is to be ascertained and given effect. They should be construed reasonably in relation to the purposes they are intended to serve, so as to give reasonable effect to the objects sought to be accomplished. It may be said in general that ordinances are to be construed benevolently, and that the terms of ordinances and statutes alike are subject to certain practical limitations. A construction of police ordinances should not be adopted which is super technical and results in defeating instead of effectuating the obvious purpose of their enactment. Ordinances must be read and construed as a whole or as an entirety in the light of circumstances existing at the time of their adoption, with proper regard for the consequences which would result from giving them a particular meaning. The courts must keep in mind the object of purpose of the enactments and the evil consequences which the lawmakers intended to guard against by their adoption. It has been held that there can be no intent deduced from an ordinance other than that which is expressed in its words, but it has also been held that which is implied in an ordinance is as much a part of it as that which is expressed. Important there. Let's read that again. It has been held that there can be no intent deduced from an ordinance other than which it is expressed in its words. But it has also been held that which is implied in an ordinance is as much a part of it as that which is expressed. I mean, if that's not legalese, I don't know what is. In construing an ordinance, words employed will be taken in their ordinary and proper signification, unless it is plainly necessary to enlarge or modify the signification in order to effectuate the plain intent of the municipal legislature in the enactment of the ordinance. A general term in an ordinance takes this meaning from the sentence in which it is employed. Section 399, liberal or strict construction. Ordinances in the promotion of safety and health of the community are to be liberally construed, and ordinances containing grants should be construed liberally in favor of the public. Penal ordinances of a municipality are akin to criminal statutes in their nature, and it will not be presumed that the legislative department of the state has delegated to a local and inferior body a greater right and more liberal rule in the definition of offenses than that claimed and exercised by the legislature itself. So you can't outlaw something the legislature hasn't outlawed. The rules applicable to the construction of penal statutes apply with equal force to the construction of penal ordinances. Accordingly, penal ordinances, like penal statutes, are usually strictly constructed. They are not to be extended by implication and are limited in their application to cases clearly described by the language employed. A person charged with a violation of an ordinance should not be punished unless it clearly appears that he is within the meaning of the terms used. It has been held, however, that the penal ordinances are not always to be construed literally, and that the courts will make the necessary exceptions. The rule of strict construction of penal ordinances is open to the limitation that the construction must not be an unreasonable or forced one. Even penal ordinances ought not to be strictly construed as to defeat the obvious intention of their passers. They should receive a rational interpretation, and the court should look for the reasonable sense of such ordinances. Ordinances which are in derogation of the common law, or which are restrictive of rights of owners of private property, have been held to be subject to the rule of strict construction. So we see the difference between public and private property. We see that the legislator has to expressly grant the permission to the municipal corporation to do whatever it does. So if the legislator has not tasked that municipal corporation with sewage treatment, then that municipal corporation is not allowed to create ordinances and laws regarding sewage, or whatever topic that you might be interested in talking about. This concludes our overview of the municipalities, and I hope that you enjoyed it. And I learned a lot from reading this section. If you get in the Telegram channel, the entirety of the municipality section is posted. You can find in law document resources under AmJur, And I would highly recommend everyone read it for themselves. But I will post this abbreviated document in the show notes below. And you can read some of the court cases that clearly give you examples of everything that we're talking about. And so there's, as you can see, there were plenty references about how they came to the conclusions they came to in the wording. So hope you enjoyed it. Please let us know what else you want to hear next, and we'll try to get it out for you. We'll see you next time on the Legal Beagles podcast.